Good afternoon or good morning, depending on where you're located, and want to welcome you to the orientation for AAA Healthcare Neutrals to learn about the new healthcare payer provider arbitration rules. My name is Michelle Skipper, and I will be hosting this orientation along with a few of my colleagues who are scattered throughout the United States. Let's begin by, first of all, let me acknowledge we will be addressing questions, and there will be an opportunity. There's a discussion box that is set up in the top left-hand corner where you can write in questions, or if you prefer, at the end of the session, we will unmute phone lines to allow live questions to be asked. Please note that during the orientation, we will not be addressing any questions until the end of the session. Okay, so today we're going to cover not only the information about the new payer provider rules, but we thought it was important for healthcare neutrals to understand and see some of the work that is being done to really help promote AAA healthcare. So we're going to talk a little bit about the AAA Healthcare Dispute Resolution Advisory Council. We'll talk a little bit about the history and how the rules were developed and how they evolved. Who was actually at the table helping provide insights and recommendations and advised AAA on such a set of rules. We will then outline some very specific changes and differences from the payer provider rules with regards to the commercial rules. We'll also address some of the resources and forms that we have available and will be available not only for neutrals, but for potential users of these specific set of rules. We'll highlight some of the marketing and promotion that is scheduled for these new rules, and then we'll also let you know about some future education programs we have planned that will involve these new rules. I want to start by, first of all, ensuring that our neutrals understand and know that there is a AAA healthcare team. And I want to begin by acknowledging and identifying the folks you all probably work closest to, and those are all of our healthcare managers of ADR services. Depending on where you're located across the country, you would work with the various centers that actually administer such cases. So if you're located on the West Coast, you're going to be working with our team from our Fresno office, who are our healthcare managers of ADR services, who are Terry Martinez and Jen Neilmeyer. If you are receiving cases out of our Dallas Central Case Management Center, you may have worked some with Sheena Lively. If you're getting cases out of our Atlanta, Georgia Southeast Case Management Center, some of you all may work with Marvin Harris and his team. And then lastly, our Northeast team located in Providence, Rhode Island, is led by Karen Fontaine, who is our manager of ADR services. And please note, these are all of our managers of ADR services, and they have a support team that work with them to help administer all of our healthcare cases. From a business development perspective, I, myself, and Bob Matlin out of our Chicago office lead some of the efforts in driving new opportunities in the healthcare arena. So I'm sure I've spoke to, if not one or two of you all, many of you all that are participating with healthcare cases. And then lastly, I want to identify the folks internally at AAA that were very involved in the development of this set of rules. Besides myself, there was my colleague Bob Matlin out of Chicago, Gene Baker, who is out of our Washington, D.C. office, and Jeff Garcia, who leads our Western Case Management Center. So I want to start by giving a little bit of background and history about, some of you all may or may not have heard, but a few years ago, AAA established a Healthcare Dispute Resolution Advisory Council. The group started evolving in the fall of 2008, and we actually formally had our first meetings in 2009. What was important when AAA was putting together this advisory council was to ensure that there were major stakeholders from the industry represented. So we were interested in having folks that represented the industry. So we ensured that we had health plans represented. We ensured we had providers represented, hospital folks, the AMA folks. With all the buzz with the electronic health records, we wanted to have the folks from the Health Information Management System Society involved. We also wanted to ensure that we had major providers from the large institution. And then we, of course, also had outside counsel that focused in the healthcare arena. And so this group has been together since January 1st, 2009. They meet several times throughout the year. And so you may hear more about this team. They do serve about every 3 years, and so we'll be rotating folks off and aspiring to have new folks join the advisory council. When we put the group to the advisory council together, we created a mission that we wanted these stakeholders to help guide and advise AAA on. So what we wanted this group to provide was to create a forum which would allow healthcare professionals to lend their expertise in fostering and developing dispute resolution solutions that would benefit the industry. So that is our mission as we move forward. So this group, when we first got together, we were contemplating and looking at what are some of the major dispute areas that utilize arbitration. And one of the core areas that utilizes arbitration was in the payer-provider reimbursement area. And they represented a very large caseload for the industry. So we identified the major stakeholders that would be involved in this dispute type, and we had them come together and provide some guidance and some direction. And they worked along with the internal AAA rules team. So collaboratively, these teams came together. The rules were vetted through our AAA legal and our practice committee during the fourth quarter of last year. And lo and behold, here we are with our new rules. Now, when this committee began to look at potentially a new set of rules, we set aside a goal and what we wanted to accomplish. And the goal was we wanted to ensure that no matter what set of rules that was developed, we needed to ensure that it would be broadly accepted by the industry and that we evaluated and considered the unique traits of payer providers which could offer efficient and cost-effective resolution. So that is the goal we had in mind as we looked at the unique traits for this unique dispute type. So the rules became effective on January 31st. You can actually visit the AAA website and find the actual rules. So there's a comprehensive set of rules there. And you can also get to the information by accessing the AAA Healthcare landing page to learn more about the types of healthcare disputes that AAA is administering. So we have that. We also are ensuring that any of these reimbursement cases that are being filed after this date, we want to ensure that they're going to be offered the opportunity to utilize these new rules. We've also developed an FAQ, a preliminary hearing scheduling order, and a comparative table that should be able to utilize and help not only neutrals, but any potential users for this new set of rules. And then we'll talk a little bit about the administrative tracks, which are a desk telephonic track, a regular and complex tracks. So as I said, after the 31st, any of these reimbursement cases that are being filed, our healthcare managers of ADR services and their teams are offering these new rules, and through mutual agreement, if both parties want to agree to use them, then we will administer the cases under the new set of rules. We've also included in our initial letter that there will be information that will outline these new rules, again highlighting these potential parties to at least acknowledge and think about the utilization of this new set of rules. So now let's talk a little bit about some of the features and benefits of these specific rules, just to give you a general sense and idea of what some of the features and benefits are of these rules, and then we'll talk a little bit more about how they may differ and drill down into specific rule identification for these new rules. One of the key features is, regardless of the amount in controversy, the parties may agree to one of three administrative tracks. It will either be a desk telephonic track, a regular track, or complex track. So a little bit differently than our commercial rules in that the claim amount drives the administrative track. Well, with this set of rules, the parties are going to dictate which track would be applicable or have the dispute administered under. The parties would pay the applicable filing fee based on the claim amount or counterclaim, just as they do now with commercial claims. Parties may request and utilize the desk telephonic track to help reduce cost by using telephonic hearings. Parties will have access to a national health care panel where these individuals that have applied for this panel have been vetted and have demonstrated knowledgeable experience in handling these types of cases. These cases will be heard by a single arbitrator regardless of the amount in controversy, of course, unless the parties want to agree otherwise. A preliminary telephonic conference with the arbitrator will be convened immediately after appointment of the arbitrator. And this we set up so it will really help facilitate the document exchange and discovery. So this was very, very important to both payers and providers to more efficiently streamline the proceeding by including this for every track. So if you pick the desk track, the regular track, or complex track, this telephonic conference will occur with all three tracks. Another feature is parties will have the ability to group claims involving different patients and the same provider and payer in a single arbitration. Parties will also have the opportunity to substitute patient claims, and this will be done prior to the appointment of the arbitrator. As we've talked about, the discovery shall be more streamlined, of course, unless the parties want to agree otherwise, or if the arbitrator decides otherwise based on some existence of extraordinary circumstances. We have included, as we do with all of our standard sets of rules, a standard clause that can be incorporated into agreements. And so this is included in the actual set of rules. So if you're advising clients on how to utilize these rules or how to embed a general clause that would call for this specific set of rules, it is included in the rules. So let's begin by looking and drilling down about more specifics on the utilization of these rules. And let's begin by looking at R1 of these rules. And R1 calls for the agreement of parties and the applicability. And very specifically, the rules limit the filing of a case to a payer or a provider, and it does exclude consumers. Now, this group, we had to define who would be a provider. And so between payers and providers came together and said, here is a definition that will fulfill the defining information for what a provider or who a provider is. So the definition for a provider is it's the hospital or hospital system, physician or physician group, laboratory services provider, ambulatory care center, dentist, chiropractor, optometrist, therapist, nurse, or other party that provided health care services and seeks payment for one or more claims from a payer. We then had to define who the payer was going to be. Under Rule R1, we define the payer as the insurance company or the other party responsible for paying all or part of a claim relating to the rendering of health services or administering the payment of such a claim for another entity. This does include third parties who administer self-funded plans on the plan sponsor's behalf, but it does not include employers who sponsor benefit plans. So in order to use these rules, these definitions must be fulfilled. Continuing on, looking at R1D, the parties may, in their arbitration submission or agreement, designate the set of procedures, which means the track that would be utilized to govern the administration. And it's one of three tracks, either the desk telephonic track, the regular track, or complex track. If the parties fail to designate or to reach an agreement as to which track shall govern, AAA will administer the arbitration in accordance with the regular track. Continuing on regarding which set of procedures might govern under R1D, a little bit more information about the desk telephonic track. This track consists of rules R1 through R54 as amended by D1 to D6. This track calls for the resolution of this dispute to be resolved through documents only, which we refer to as desk telephonic. There's an opportunity for telephonic hearing through D5, which allows a party to request or the arbitrator may order one or more telephonic hearings to supplement a documents-only hearing. This was very important to the group when they were considering this track because many of the payers and providers indicated there are often times when these issues, they can be a very large case amount with very simple issues that could easily be resolved as long as the parties had opportunities for advocacy through their submission of documents. So we ensured that we included opportunities for the party and for the arbitrators to order telephonic hearings as necessary. The other thing that was important is both payers and providers wanted to ensure that it wasn't just a set of, here's a set of documents, arbitrator, go figure out what you need to decipher. So that will be important that both sides had the opportunity, as well as the arbitrator, to allow for telephonic hearings. The appointment of the arbitrator for this track will be through a list of 10 proposed arbitrators. And if for some reason the parties cannot make the appointment from among those listed, then AAA will be given the power to make the appointment from among other members of the national healthcare roster without us having to submit an additional list. Again, we're trying to keep the case proceeding and moving along, and we're looking for the efficiencies. The regular track consists of R1 through R54, and the complex track consists of R1 through R54 as amended by C1 to C5. One of the unique rule sets for the complex track is Rule C4, which allows the parties to be limited to 2 depositions unless otherwise agreed to by the parties or ordered by the arbitrator for good cause. The expertise of neutrals, R3, requires that AAA establish and maintain a national healthcare roster, and that by default the arbitrator will be selected or appointed from the specialty panel. Just to give you all some perspective, the AAA, all of you all that are on this call, are members of the commercial panel for AAA. One of the sub-panels for the commercial panel is healthcare. And under healthcare, we have 5 major category areas, and neutrals that have been able to demonstrate expertise in one of those 5 areas have also been coded in one of these specialty areas. One of these specialty areas is payer-provider reimbursement disputes. So all of you all that are on this call today have been coded to that panel to hear such cases. And so on the National Healthcare Panel, AAA has over 330 neutrals. Specifically on the Healthcare Payer Provider Reimbursement Panel, there are over 100 to hear these cases, and this, again, is nationally. Continuing on and looking at R4, a payer or provider may file as a single case all reimbursement-related claims, including those involving multiple patients and or multiple dates of service arising under a single contract. R4B further clarifies and offers the ability for a payer or a provider to file as a single case all reimbursement-related claims, including those involving multiple patients and or multiple dates of service, arising out of multiple contracts between a specific payer and a specific provider. We had to further include this rule so that AAA could remain silent with respect to any type of class action. So we further enhanced R4A into R4B to provide some more clarification and allow us to remain silent in class resolution. Change of claim or counterclaim. The rules differentiate very specifically between that of a substitution of a same or similar health care reimbursement claim or counterclaims versus the assertion of a new or different health care reimbursement claim or counterclaim. So let's look at R5, which defines the substitution of a claim or counterclaim and how and when it might occur. The substitution of a same or similar claim or counterclaim involving the same or different patient and the same provider and the same payer is allowed prior to the appointment of the arbitrator. And it's allowed provided that the substituted claim or counterclaim is equal to or less than the amount of the withdrawn claim or counterclaim. Absent party agreement, substitution will not be permitted following the arbitrator appointment. And then lastly, any disputes concerning whether a claim or a counterclaim is the same or similar will be resolved by the arbitrator. Now, in looking at a change of claim or counterclaim R6 with regards to the assertion of a new or different claim or counterclaim, again, it is allowed prior to the appointment of the arbitrator. Once the arbitrator has been appointed and absent the agreement of the parties, the arbitrator may consent and it may be sought and may be agreed upon as long as the arbitrator has taken into consideration that the alleged grounds for payment of the claim or counterclaim is the same as for the claim or counterclaim already pending, and it will not unduly disrupt the efficient administration of the arbitration to add the claim or counterclaim. R10. R10, again, states that the dispute will be heard and determined by one arbitrator, regardless of the amount in controversy. R18. This is where the team evaluating and developing the rules really spent a lot of time because, as we said, this set of rules does require all tracks for AAA and for the arbitrators to host a preliminary conference and scheduling order hearing to address several different issues with the parties. And so the group really spent a long time looking at what was really, really necessary. So in looking at R18, the preliminary hearing shall be held among the parties and or their representatives and the arbitrators, again, regardless of the track or procedures under which the case is being administered. And the reason is they want the rules call for certain issues to at least be addressed or considered. One includes whether or not parties wish to enter into a confidentiality agreement. And such confidentiality agreement could cover information that might be exchanged by the parties through the course of the arbitration or any award entered by the arbitrator. Another consideration to be addressed is whether or not the parties wish to agree that the ruling made by the arbitrator with respect to contract interpretation issues shall be binding upon the parties for the remainder of the duration of the contracts at issue, of course subject to the outcome of any appeal. The other area for consideration is whether or not the parties wish to agree to include in the arbitration any additional similar claims under contracts with one or more affiliated parties, and that would have to be subject to the consent of those affiliated parties. And then lastly, the content of the initial disclosures as outlined in R18E. In R18E is a set of, it's an exchange checklist that will be provided and available for parties and for the neutrals to evaluate and look to determine who's going to be exchanging what information and when it might be exchanged. But it's very detailed. There's very specific information that pertains on the payer side and very specific information that is provided on the provider side. So it outlines some potential information that may be exchanged. We also said that we did develop and included in the preliminary hearing scheduling orders the information that has all been contained in R18E. So there is a scheduling order for the desk telephonic track, and there's also one for the regular and complex tracks. And these will all be available and uploaded in our Normandy system, so you will have access to it. So again, the arbitrators and parties will receive the blank orders prior to the preliminary hearing. And as many of you all have done, you all take the standard order and tweak it to accommodate and meet your needs. And so you can take this order and tweak it as you deem necessary. So again, you'll receive it, and then you can use this or you can develop your own. So let's talk about a little bit about the discovery and how it may differ from each one of the tracks. With regards to desk telephonic track, it does prohibit the ordering of any depositions or other methods of discovery absent any type of extraordinary circumstances and finding of good cause by the arbitrator. With regards to the regular track, the parties are limited to one deposition each unless otherwise agreed to by the parties or ordered by the arbitrator for good cause. And this is outlined in Rule R19. And then with regards to the complex track, the parties are limited to 2 depositions each unless otherwise agreed to by the parties or ordered by the arbitrator for good cause. And this is outlined in C4. Restrictions on the dissemination of the award. R46.8 specifically prohibits, absent any written agreement of the parties or unless required by law, the dissemination or publication of the award except to the extent necessary to effectuate the enforcement of the award following issuance of a court order. So it is prohibited for any publication unless outlined in 46A. Continued on with regards to restrictions on the dissemination of the award, R46B specifically states that absent written agreement of the parties, the award shall have no res judicata, collateral estoppel, or presidential effect. Now let's talk a little bit about the fee schedules. The administrative fees will be depending on the applicable fee chosen by the parties. If they're choosing to use the standard or flex schedule, that will determine what the administrative filing fees will be. There is a substitution fee. So when parties are substituting claims, there will be a substitution fee charged to the party requesting the substitution. And then lastly, and I'm sure most importantly for you all that are on this call, arbitrator compensation. The arbitrator will charge their published rate. So there will not be an expedited panel for this set of rules. So for the desk telephonic track, the arbitrator will charge their published rate. For the regular track and for complex track, again, the arbitrator will charge their published rate. It was very important when the group was evaluating this, was determining that they really wanted the arbitrators to charge what their published rate would be because each situation was going to be uniquely different. And so they wanted to ensure that the arbitrators had the ability to do that. Listing of neutrals. It will be important. Those of you all that are on this call, you will need to go to the Neutral Center and update your resume. So it will reflect that you attended today's orientation. All of the managers of ADR services, when they're beginning to list folks for such cases, are going to look to see if this designation has been included in your resume. We will only be listing neutrals that have attended this orientation. There may be some neutrals that are unable to attend, but we've recorded the sessions, so they'll be able to listen to the orientation, and then upon the conclusion of completing and listening to the orientation, they'll be able to update their own AAA resume as well. I will be sending a follow-up note to all participants and to all neutrals that are coded to this particular panel. Again, reminding everybody of the instructions on how to update your resume and what language you should include, along with a link to, again, listen to the orientation if necessary. A little bit, again, about some of the resources and forms that we have available. And, again, these are for not only neutrals but for potential advocates and users of the rules. By going and accessing the AAA Healthcare landing page, that's where the set of rules will be housed. There's also a comparative table which outlines some of the differences in a table format between the commercial rules and the payer rules. There's also an FAQ that's been developed, so you can take a look at that. And as I said, all of our case management and managers of ADR services will all have the preliminary hearing and scheduling orders available for all tracks. They will be uploaded into our case management system, so they will be available for you to use. And then lastly, some of you all may participate on this call today and may not get assigned a case for 9 months. And some of you may say, gosh, I really would like to familiarize myself with the rules. I'd like to go back and listen to the recording of the orientation. We will have that available at least up to about a year so that folks, neutrals, when they get a case and they want to get more familiar with it, they can listen to the orientation or they can just access the rules. From a marketing and promotion perspective, we do have a couple of members of the AAA Advisory Council that are going to be featured in our upcoming Dispute Resolution Journal that will feature, again, more information about these specific rules. We're also going to be really promoting the introduction and introduce these new rules to many, many of our customers, some of our health plan folks, some of our hospital folks, any advocates and potential users. And then we do have a new ad that is going to be going out, and we're going to be hitting some very strategic healthcare journals and publications. And then lastly, we just tell you, continually go to the AAA Healthcare landing page because that is evolving and we'll be adding and including more information about some new initiatives that are underway with AAA Healthcare. Lastly, let's talk a little bit about some education programs. We will be hosting a webinar for any customers and or potential users on these new rules mid-April. So we will be promoting this and encouraging folks to attend and participate on this program. Well, we're at the very end, and now what we're going to do is we're now in the session where you have an opportunity, if anybody has any questions, depending on your comfort level, you can either write them into the dialogue or discussion area, and we have some folks that are monitoring that box for us. Or if you prefer, when we tell you, you can unmute your phone line and ask your question and then remute your line. But before we do that, we want to address, there was a couple of questions that were addressed in the earlier orientation. And my colleague, Jean Baker, is going to address two of those questions that came out. So, Jean, do you want to unmute your phone line and ask and then answer the two of the questions?
Sure. Do you want me to give the question and then the answer?
Yes, please.
Okay. The first one, are there deadlines for parties' agreement on various issues or for motions to be submitted, like good cause for more depositions? As a follow-up, would deadlines for such motions be addressed in the preliminary hearing? Within the rules themselves, there are no set deadlines, so these are issues that would be addressed in conjunction with the arbitrator during the preliminary hearing. And you would set the timeline. Certainly if you are conducting a desk arbitration, timelines would be established for the submission of any and all documentation. The next question, if a payor files a claim directly against an employer-sponsored plan and there is an arbitration agreement in that contract, and then the plan files a third-party claim against a TPA, and again there is an arbitration provision in that contract, which rules should apply? Well, the short and easy answer is that if a payor files a demand for arbitration against an employer-sponsored plan, and then the employer-sponsored plan files a demand for arbitration against their third-party administrator, neither dispute involves a provider as defined by the healthcare payer provider rules. So both disputes would be resolved using AAA's commercial rules. Since neither the commercial rules nor the healthcare payer provider rules have any provision for consolidation or joinder, if the commercial rules are governing both of these disputes, the parties would either have to agree to consolidation or joinder, or they would be proceeding as separate arbitrations. I'm assuming that the question was raised because someone really wanted to know what happens if there is a disagreement as to whether a party filing an arbitration under the payor provider rules, if there's a disagreement as to whether they meet the definition. If there's any disagreements as to whether a party is a payor or a provider as defined in the rules, that's going to be decided by the arbitrator. The reason we wrote definitions of payor and provider into these rules is because we wanted to be very clear these rules really do not govern disputes involving consumers, employees, or recipients of health care services. AAA has distinct policies, procedures, and rules governing disputes involving consumers, employees, and health care recipients. And so we wanted to, in some way, make it very clear that those individuals would not be appropriate parties for use of these rules because these rules do not have all of the due process protections that have been written into our consumer supplement and our employment rules. So those are answers to the questions that were raised yesterday.
And there's one more that I'm going to follow up with, Jean. A question arose that asked if parties to a health care dispute which does not involve the defined payers and providers, but they wish to submit the dispute by agreement under these rules, would it be accepted by AAA? And the answer is the parties must fulfill those definitions in order to use this new set of rules.
Well, let me kind of disagree maybe a little bit. I think that look, if the two parties are business entities and they wanted to get together and by stipulation, prior to filing the demand with AAA, if they wanted to create an arbitration agreement that says we agree to conduct our arbitration and then kind of pull procedures out of these healthcare payer provider rules, AAA would not challenge that.
Correct.
Arbitration is a creature of contract. The parties can create whatever process they want provided they are two business entities.
Correct.
So I think the only time AAA would really get concerned is if if someone was trying to force a consumer, healthcare recipient, or an employee into an arbitration using these rules, then I do believe AAA would step in and say, no, it's not appropriate, and we have policies in place that would allow us to do that. At that point, clearly parties have every right to go to court and, see if a judge wants to disagree. We have a policy that says we won't use the commercial rules when a consumer is involved in a dispute, but we have had courts order us to handle consumer disputes using commercial rules. So that's why there's sometimes there's no easy answer to some of these questions.
Good. Now, at this time, we will take any questions either in the discussion area or if you wish to ask a live question, if you will hit *6 to unmute your line, ask your question, and then if you can hit *6 to mute your phone back. That way we're just trying to minimize any of the background noise.
Greetings. Here's a question.
Okay, hold on. One at a time, please. I'm sorry.
Okay. My question is, if the parties to a payer-provider dispute who filed their case, let's say last December, if they would like to take advantage of these rules, I assume that would be permissible.
The rules are effective as of January 31st. So any cases that have already been filed and we're in the midst of administering, they will continue to be administered under the set of rules that were applied at the time the case was filed.
Okay, thank you.
Mm-hmm.
I'll jump in. Jerome Landau, greetings. First off, there's a discussion area on the computer monitor where it says say, and if you type in your response, it doesn't tell you how to send it. That aside, if in fact the payer-provider rules do not include a situation and the commercial rules do, are we then able to default to the commercial rule?
Yes, you'll be able to, yes. If it's a situation that would lend itself and that would not meet the needs or the parties don't mutually agree to the payer-provider rules, and again, as long as the agreement or the parties both mutually agree to use the commercial rules, they certainly can.
Thank you. I expect that this will always be a work in progress.
Correct.
Well, okay, and remember, the healthcare payer-provider rules were integrated into the commercial rules to the extent applicable or appropriate. So if I'm not sure exactly what type of situation you were envisioning. Clearly, if the parties agree to vary procedures, we state that the parties can do that. After appointment of the arbitrator, you're probably going to have to get the agreement of the arbitrator. But again, arbitration is a creature of contract. Party agreement pretty much trumps, provided the parties are both business entities. So, I'm not so sure that this is there's not going to be any AAA forcing parties to accept procedures that they're not comfortable with, provided both parties are in agreement as to how they want to proceed. Does that make sense?
Well, yes. So is it safe to say that the commercial rules are in effect as amended by the payer-provided rule?
That is not correct. These are standalone, independent healthcare payer-provider rules. We originally created a supplement, and that used to be AAA's approach to crafting procedures tailored for specific types of disputes or specific industries. But what happened is sometimes we didn't take into account, just as you've indicated, that maybe there were discrepancies between the supplement and the commercial rules. So this time, moving forward, the AAA has decided that every set of rules will be an independent, standalone set of rules. So what we did is we took the commercial rules, all those standard boilerplate provisions that everybody is very familiar with. We then integrated those standard rules with the healthcare payer provider supplement, and when there were conflicts, the healthcare payer provider supplemental procedures, they were the ones that we utilized, and we deleted the standard commercial language. So that's the approach that we've taken.
Got it. Thank you.
Okay. And hopefully we did a good job, but as you said, it's a work in progress.
Yes.
So these rules, of course, are not in the contracts at the moment. So when somebody files an arbitration demand, will the case administrator then propose these rules to the parties?
Yes. If you what we have done is in the initial letter acknowledging the case for the parties that do meet the definitions of payers and providers, included in the letter is reference to the new rules so that the parties can be offered a choice if they'd like to use, if they want to mutually agree to use those rules. Otherwise, it will be the rules that are named in their agreement.
Thank you.
Mm-hmm.
I have a couple of questions about resumes.
Sure.
When you send out the listing of the 10 arbitrators, will you be providing the standard commercial panel resume, or will we have an opportunity to prepare a resume that's more focused on healthcare experience, sort of the way AAA does with energy, for example?
Yeah, right now it would be it's a standard healthcare, it's a standard AAA resume. What I might encourage some of you all to do is within your resume, under your ADR experience or under your professional experience, you can include a heading and label it healthcare and describe some of your healthcare experience. As we move forward to some of our new platforms, my understanding is we will have the ability in the future to have neutrals have a dedicated, here's a healthcare resume, here's a commercial, here's an energy, but right now our current platform does not lend itself to that. So what some folks have done is they've taken their AAA resume and included into various segments of their resume, they include a heading called healthcare, and that's where they might write and describe about some of their healthcare expertise.
And then one follow-up.
Sure.
Would it be accurate for those of us who are on this call to include a notation in the commercial panel resume saying that we are members of the AAA National Healthcare roster?
Folks know that because in order to be coded to hear such cases, your resume would not be going out for some of these healthcare cases if you were not a member of the National Healthcare Panel.
Would the user understand that, or would it be helpful to them to just include this in the list of the panels that we belong to?
I think what's more useful is for you to ensure, and that every neutral ensures that they really include the depth of your expertise in the healthcare arena, where it really demonstrates where your expertise is within the industry, because that's what they're looking for.
Okay, if you want some feedback, I think the sooner you can get to dedicated resumes, the better, because many of us work in several different fields, and in order to emphasize the healthcare stuff, we're going to have to, take away from some of the other stuff that we do. And I think it'll be possible to give the users much more detailed information if we, as with the energy, for example, if we do a focus.
Yeah, and one of the things we are doing, and we're going to continue to do, especially as we recruit members to the healthcare panel, is we, like some of our other special panels, have set very specific qualifications. And so neutrals need to ensure that they can, we're ensuring that they can demonstrate that they're spending a certain percentage of time in this arena. And so if neutrals can't demonstrate that they can, then they will not be considered for the panel.
Okay, thank you.
Mm-hmm.
I have a question regarding what I think I heard you say. Are there going to be other types of healthcare panels besides the provider-payer rule panel?
Yes, there are 3 other panels, and most of you all, about a year and a half ago, we created a supplemental healthcare form. And so when we sent that out, many of you all completed that form, which demonstrated expertise in several of those different panels. So when you completed that form, that allowed us to provide additional panel codes for that expertise.
Are there new rules for those other types of panels also that are being?
No, they're not. They're just commercial. They're all just going to be using the commercial rules.
What are the other panels, the categories?
There's one called Panel Expertise and Transaction. There's one Payer and Provider. There's one on contract issues, and there's one for hospital and peer review credentialing.
Okay, thank you.
Mm-hmm.
Are you going to, are you advised that we don't send any amendment to the resume until you send the letter out or the email out saying what to put in?
Correct. And I will be sending that out probably early next week. And it's very simple. I'm just going to ask you all to go to the Neutral Center, update your resume, and in the ADR training section, you're just going to put payer-provider orientation in February 2011, just so it demonstrates and we know that you've gone and either you participated live or you listened to the recording.
How can you tell which ones you're coded for?
I'm sorry?
How can you tell which categories you are coded for?
You can ask each of you all. I'll have a person that is similar to my colleague Jean Baker, who happens to be in D.C., and myself, where I'm located in Charlotte. There's 9 of us across the country that cover commercial for AAA. So you should know who your representative is. And if you don't know, you can write to me, and I'm happy to get you in touch with your vice president that would lead that area, because we also manage and recruit for various different panels on the commercial side.
And also, I saw there was a checklist for discovery. It was too small to read on my screen, but can I assume that I could order additional discovery, or the parties could agree on or ask for additional discovery, something not having a checkbox there?
If that's what you prefer, sure. we were just trying to provide some tools and resources as we started to begin using these new rules.
And lastly, there seems to be an emphasis on the preliminary hearing. The preliminary hearing is going to be held more quickly than in the past. I'm unaware of cases where there is no preliminary hearing.
I'm sorry. I had such a hard time hearing the question you were asking because
is the preliminary hearing going to be more quicker than in the past, or somehow different? You seem to have put some type of emphasis on preliminary hearings now.
Well, it's going to be, what's imperative is this is going to be held for all tracks, and I think with some of our other sets of rules, if we have neutrals that use other construction and employment, they may call for them. On the commercial side, it's typically if a party requests or unless it's a complex case that they're automatically done. And so in this particular set of rules, all tracks will be participating in the preliminary hearing.
Michelle, this is Terry Martinez.
Yes.
We did have one question in the discussion area. It was answered during the course of the conference call, but I'd like to read it out loud, and then we can discuss it just for the sake of all of the attendees.
Perfect.
The question was, must the parties agree on one of the three types of administrative tracks? Mm-hmm. If they do not agree, then how do the parties pick one of the three tracks?
Okay. Again, as we outlined in the rules do specify that if the parties, they can agree through their submission or through their contract, they can specify which track. If they cannot mutually agree, the default track is the regular track, and that's how AAA will administer the case. Okay, we're coming up on the hour, and I think I told everybody that the orientation would last about an hour. So if there are not any other questions, please.
One more question.
Okay, I'm sorry.
That disclosure checklist, will that be provided to the arbitrator, or is it posted on the landing page, or how do we get it?
It will be provided to the arbitrators. It will be an attachment with the preliminary hearing and scheduling order.
Thank you.
Sure. Okay, well, we're coming up on the hour. Again, I appreciate you all attending.
Can I ask one more question?
Sure.
Just want to make sure I understood this because I heard it both ways. We are not to update our resume until we receive an email from you next week. Is that correct?
Sure. That's fine.
Okay. Thank you.
When will we be able to go to the slides? Because I want to pull that link up again that was on one of the very first slides.
I'm sorry. You will break. I had a hard time hearing you.
When are we going to get the slides? Because I'd like to go look at that link that was on the second slide.
Okay. Next week, because they are recording the sessions, and so they're going to have to do some cleaning up of the recording, because I'll also be sending that link along that would have a copy of the slides.
Thank you.
Sure. Okay, any other questions?
This is not a question. I just want to say this was very helpful.
Great, thank you. We appreciate that. Again, I want to thank our team out in California, Terry and Jen, for monitoring our discussion box, and I want to thank my colleague, Jean Baker, who, again, was part of our rules team and helped address some of the questions this afternoon. And, again, look for some follow-up for us. We appreciate you all attending today's conference, and we will be sending, or I will be sending, the additional information and links so you can access these slides and listen to a recording if necessary, and we'll also provide you with instructions on how to update your AAA resume. We thank you for your time and enjoy your afternoon. Bye-bye.